Good morning or afternoon, depending on where it is that you guys are in the country today. I want to thank you for taking the time to join us for this investor update on the Profit Connect matter. I want to start by giving the same disclaimer we always give. Nothing in this investor call should be considered legal or accounting advice. And if you have specific legal or accounting questions, I recommend you reach out to a competent counsel to speak with them. Any mention of anybody in this matter, they are innocent until proven guilty by a court of law. And so I really kind of want to jump in now and talk a little bit about what the timing of events look like, what our role really is within this case, and give you some brief overview questions. As most of you know, my name is Jeff Winkler. I am the court-appointed receiver for Profit Connect. The Securities and Exchange Commission filed an action against Profit Connect and its founders, and so it's been my job to go through and collect assets, sell the assets, to do a forensic accounting to determine how much money was invested and where that money went, and then to begin a claims process to allow people to make a claim for the money they're owed, and then ultimately, which will lead to a distribution process in which you guys will begin to get paid back on your investments. The timing of the events, as I said, right now we've started the claim process approximately 1 month ago, and the process has 60 days remaining in it, which is November 11th of this year will be the final date in which claims will be accepted. Once that has occurred, we will continue to audit those claims and review them. We will work with the people that have filed those claims to help try to come to a resolution on what their claim should be. And once that has been accomplished, then we will submit those claims to the court for approval or rejection based on that information. Once that has occurred and the court has signed off on it, then we will request the court allow us to make a distribution based on those claims and the amount of money that is available to distribute at that time. So we will then, so next I want to kind of go through some of the questions that we got from investors, and we did receive a number of questions, approximately what works out to be about a page and a half of questions. So we're going to go through those, as quickly as possible, but to allow you guys to kind of understand what exactly is happening. So the first question we have is, understanding the claims process and what that is. So we've done a full forensic accounting to help determine how much money we think investors put in and how much money went out. And so the claims process is really to help solidify that information and to make sure that there are no disagreements, or that there was not money that was invested in a different way or through a different account that we have knowledge of, in order to try to locate those, but to also ensure that the people that invested, that their claims are recognized for the amount that is the proper amount. So that's really what the claims process is about, is working with investors to help make sure we have a good understanding of what their claim is, and then putting those forward to the court and allowing the court to adjudicate those based on what we believe is the right number for each investor. So with that in mind, let's just get into some of the general questions. The first one is, when can we expect conclusion on the receivership? That is a question that we actually don't have an answer to at this point. As I said, the claims process ends in the early to mid September 11th. And once that happens, then it'll go in front of the court for the court to adjudicate. And that, of course, will take a certain amount of time, usually 30, 60 to 90 days, somewhere in that range. And once that's happened, then we will request the court allow us to do a distribution. So we will submit a distribution plan, and the court will have an opportunity to review it, as well as all the investors, and to be able to opine on any questions or comments that come about because of that. We are also in the middle of some litigation right now, both clawback litigation against people that were promoters in the scheme, and also against some third parties, including attorneys, accountants, and financial institutions. That litigation sometimes moves quickly, but oftentimes does not move as quickly as we would like. But being that we see that as a large potential source of return, obviously we're going to continue to pursue it and be able to litigate some of these claims as we think that it warrants, based on the liability of the party involved and the amount of money that could potentially be recovered for the estate. The next question is, how much money was spent investigating this matter for the court? So the investigation is not yet complete. It has cost, it has cost hundreds of thousands of dollars to do. As you guys are probably aware from some of our previous reports, there was no accounting that was available to us when we got into the case. And so we essentially had to recreate the accounting from scratch, from bank records, copies of checks, wire transfers, talking about dozens of accounts over a multiple year period of time. And then, of course, tracing assets based on that. So when we go through the accounts and we see that things have been purchased, we want to make sure that those things were on site when we took over control of the business. And if not, going out and seeking those assets for recovery. Every dollar that we can recover is money that can go back to investors. And so we take that role seriously. We will obviously do a cost benefit analysis. We're not going to spend $100 to get $100. That doesn't make any sense. But we will go after the things that we think, that there is a substantial return for investors and it makes sense to do so. Is it typical for the investigation to take as long as it has? And the simple answer is yes. These cases oftentimes take 3 to 5 years, sometimes even longer. I've been involved in one that's taken a dozen years. So it depends on the complexities of the case, but we don't have to get to the end of the case for a distribution to occur. Once we get this claims process wrapped up, we can start distributing funds based on what we have available to us. And then as we get, additional substantial funds, for example, if we settle with one of the financial institutions and we get a lump sum payment, then we will schedule to do a distribution after that. Once the plan's been approved by the court, we don't have to go back to the court each and every time to do an additional distribution. We will just do so when there's enough money available that it makes sense to do that. And is the process wrapping up now, and how will we be notified? So the process is not yet wrapping up. As I said, we've finished the forensic accounting piece. Now we've moved on to the claims and the distribution. And then we have this litigation piece. And oftentimes the litigation piece can take a couple of years in and of itself. However, during that time, we are not doing a lot of other work. So there's not a lot of, bills being applied to the estate. We just do it based on the work that needs to get done. And so if it's in litigation, then the focus will be on the litigation. Usually when we hire attorneys to do this work, it's on a contingency basis. So they get paid if we get paid, based on a percentage of that. Although some of the smaller stuff we will do on an hourly basis based on a cost benefit analysis. The next category of questions falls under defendants and agents. It says, I'm under the impression that I cannot file suit against anyone connected with Profit Connect as long as the receivership is in effect. Is the statute of limitations told why the receivership is pending? So the answer is, can you file the lawsuit? The general answer is no. The order that the SEC gets in the beginning of this case prohibits litigation against any of the parties, and it's done so because we don't want investors going out and suing one of the responsible parties on their own, for their own benefit. The idea is that the receivership estate will file those suits, so there's only one cost for one set of attorneys, and that all the money then goes back to all investors equally based on their pro rata based on their approved claim. The question of whether or not the statute of limitations is told, that is a question for an attorney, and I can't honestly give you the legal advice related to that because I'm not representing investors as an attorney. What were Eric Garrison and Arnold Thompson, and what were their involvement in Profit Connect, and are they being held responsible? Eric Garrison and Arnold Thompson appear to be promoters in Profit Connect, and much like all other promoters, they're being asked to return any of the profits that they made or commissions that they made as part of this case. As you know, that this was not a legitimate investment, and there were no legitimate profits made. And because of that, any money that was paid out as commission or as profit is being asked to be returned because they are false profits, false commissions. And anybody who refuses to return them voluntarily will be, we will look to litigate against in order to get those funds back. So far, most of the people we've been working with have been very cooperative, and we hope that that continues. Our goal, of course, is just to make it, to make the situation as good as possible for everyone involved and make sure that everyone is treated the same. Will there be trials held for Joy Kovar, Brent Kovar, so they can do jail time? So as you're aware, the SEC, when they bring their case, that is on a civil basis for securities fraud. If the parties ultimately can't come to an agreement, there could be a trial on the civil side, but that would only lead to a monetary judgment and not to any jail time. In order for jail time to be considered, the United States Attorney for the District of Nevada would have to pursue claims against the parties. As of today, there is no indictment that has been filed, and so we don't yet know if the U.S. Attorney will be pursuing claims or not. If you do believe that they should, I would highly recommend you reach out to the U.S. Attorney's Office in the state of Nevada and let them know your feeling on that matter. The next question, are you investigating all sales agents and recovering their sales commissions? I touched on that above. Yes, we are reaching out to all sales agents and asking them to return the commissions that they made. Let's see, are you investigating, let's see, have some of the investors taken legal action against Joy Kovar and Brent Kovar? As of today, there have not been any actions taken against them that I am aware of. If there is, of course, the SEC would look to have those suits dropped because it would be a violation of the court's restraining order against litigating with them. Our goal is to get back as much money as possible. If we believe that there are funds available with Joy Kovar or Brent Kovar, we would litigate against them to get those funds. The SEC, of course, will be looking at a judgment in their case as well. And typically any money that's gathered through restitution will be turned over to the receivership and distributed to investors. Dave Bynum was running an education program promoting Profit Connect and recruiting agents. Is he being investigated? We can't go into into the individuals that are being investigated, but I can say that anybody who was responsible for the scheme as it was promoted and profited off of it in any way, all those are being reviewed and potentially will be litigated against if they choose not to return the money voluntarily. Are there any criminal charges or expected charges against the original owner? Again, that's up to the U.S. Attorney. I can't comment as to whether or not there's anything happening today. But if you do believe that something should be happening, I would encourage you to reach out to the U.S. Attorney's Office for the state of Nevada and let them know that you're concerned and you think that something should be happening. Questions next about the forensic accounting. How much of the funds recovered are confirmed in control of the receiver and how much is pending? So as of today, we have just about $9 million in net assets that we've collected. We do believe that there are a minimum of a few million additional dollars that will be recovered from promoters and net winners. And then we, of course, believe that there are also additional sums of money that will be available through litigation with third parties, including attorneys, accountants, and financial institutions. As you guys have seen, we've requested the court give us permission to file a lawsuit against Bank of America. We do believe that we have a very strong claim there, as do the attorneys that we have hired to litigate it. They are very experienced litigators and have done this in numerous cases of very similar design and have been very, very successful in that. When we chose them very carefully based on results that we've seen in previous cases against financial institutions that are competent, that we will obtain a significant result because of the work that they do. Did Eddie Kona obtain wealth through Profit Connect that can be recovered? As you guys are probably aware, Eddie Kona passed away just before the receivership started. We have reviewed the assets that he had in his estate and did not find anything of any substance that could be recovered. Unfortunately, just because of the way that he had spent the money leading up to that time period. What is the approximate percentage recovered compared to what will be transferred to Profit Connect? Right now, like I said, we're about $9 million out of approximately $24 million that we believe was invested. That without any further recovery, leads, just under 40% recovery. As I said, though, we do believe that there's additional substantial recovery yet to come through the litigation with those other parties, and we are pursuing those. We have a settlement with a couple parties that have yet to be funded. And as those get funded, that will also increase the amount that is available. That number will continue to grow. I know that some of you have reached out asking questions about what is my loss because you're wanting to take that loss for tax purposes, or you've had an accountant who has recommended that you do so. Unfortunately, we don't yet know what that top number is going to be on recovery, so we can't yet advise you as to what your loss is or is not, because that number will continue to change as we gain additional funds through this litigation. Next question has to do with clawbacks. So the first question is, what is a clawback? So a clawback is where we go back after people who got money that they were not otherwise entitled to because this was an illegitimate investment. So if you got commissions for bringing people in, that we would seek to claw that back, as well as if you became a net winner, meaning that you got more money than you had put into the investment, and were therefore had gotten more than 100% of your money back. In those cases, we will typically ask for the return of the profits again, because they're not real profits, right? They were actually other investors' money that had been put in, were paid out to look like profits, but in reality were not. Will the agents who were working in good faith as Profit Connect agents and who did so from a contractual agreement with Profit Connect still be able to receive their refund as investors for their personal investment? So that question is ultimately up to the court. Our typical way that we would view this is if they return the commissions that they weren't entitled to, then they would still be eligible to file a claim for any losses that they have for investments that they had put in personally. It is rumored that agents must forfeit their commissions they received. Is there consideration for agents using those earnings for normal livelihood concerns who were unaware of the nature of their employment? The answer is that yes, we will still seek to forfeit those commissions. Now we do, look at things from a real perspective, and so we do know that there will be some hardship cases out there, and hardship cases will be reviewed on a case-by-case basis. If somebody doesn't have the money and has lost the money for legitimate reasons, then we will look at that and base some kind of settlement on that information. Will there be any clawback of commissions that were paid? I think we've touched on this already. The answer is yes. The next question: I got a letter from American Fiduciary Services requesting return of funds received from Profit Connect. Is this request legal, and what is the process? So those letters that came out from American Fiduciary Services are from my firm, and requesting the return is what we've been talking about. It is legal for us to do so. We have both permission of the court and decades of case law behind us for being able to recover these profits. If people choose not to do this voluntarily, we will sue them where it makes sense to do so, and we'll seek to get those profits returned. Our preference, of course, is always to do it on a voluntary basis, in which case, we can work with people to get things done in an appropriate manner. We can even accept payments over, a short period of time where necessary. What happens to the other principles that led others to believe that this business was legitimate? Again, we're asking for return of any funds involved in the case, but there may also be restitution judgments that the SEC may see, as well as potential litigation between myself and those parties if we believe that they were responsible for what happened, or responsible for a certain amount of investments that were brought in. The last question in this section is, what do we do if we've already paid taxes on the commission? The IRS has regulations that are set up to allow you to go back and alter the income that was claimed over a certain period of time. I would highly recommend that you reach out to an accountant or a tax preparer and let them know what is going on, and they can help you figure out the best way to refile those taxes where available. The next section deals with the claims process. Has the claims process begun? Yes, the claims process began approximately 1 month ago. The next question is, how long do I have to file a claim? You have 90 days from the beginning of the claims process to file a claim, which is November 11th of 2023. They need to be received by the end of that day. Anything postmarked after that date will be determined, will be considered late, and we will recommend, and then the court will decide whether or not to accept late claims on a case-by-case basis, but typically a late filed claim will not be allowed. If I made 2 separate investments in Profit Connect, one through myself and the second through an investment club, do I need to make 2 separate claims? So the answer is you don't necessarily need to make 2 separate claim forms. You can include both those investments in one form. There's a spot on the form that asks for aliases. This would be a good spot to put in that information. If you think that there's more information that would be helpful to us, but it isn't room for it on the claim form, I would encourage you to send us an email with that additional information if you think it would be helpful to us. And keeping in mind, too, that as we go through this claims auditing process, we're not just going to deny somebody's claim and then send it to the court and say this should be denied. If we think that there's an issue with the claim that would cause it to be denied, either in full or in part, My claims analyst will reach out to you and talk to you about the claim and what the issues are we see, and ask for additional information that might help us, resolve what that issue is. At some point, we will also send out something to you. There's a claims adjudication form where we may ask you, and some of you have seen this already, where we ask you to agree to the claim amount that we think that is the proper amount for your claim. If you've gotten one of those forms and you've signed it, then your claim is done and adjudicated and will be ready to submit to the court, pending some new information that would undo that. What should investors outside the U.S. When should investors outside the U.S. receive their postal letter talking about the potential claim? So those international letters went out at the same time that the other letters did. And it depends on the post office and the country in which you're working, but typically those can take between 7 and 14 days to be delivered. However, if you are expecting something and haven't seen it, and by this point, if you have not seen it, I would suggest that you just get on and go ahead and file a claim online, and then we can deal with your claim from that way. How do I know if my investments were consolidated or will be treated separately? So typically investments are treated on a entity by entity basis, meaning, based on how you file taxes. So if you and your husband and wife file taxes together, that would be typically considered one investment. If there is a separate tax ID number or taxes are filed separately, then those entities often will be separated for claims review purposes. But if you do have, for example, let's say you invested through an IRA or a 401k program, those claims should be filed separately because those are separate legal entities and have separate tax consequences associated with them. So we would request that those types of claims be filed separately and will be treated separately. For those of us who are investors in the commission-based affiliate agents, will our commission payouts be subtracted from the final investment reimbursements? So we typically treat those two things separately. So we are going to ask that that those commissions be returned to the receivership estate. If they are not returned to the receivership estate, then oftentimes we will seek to have the claim for the money invested be denied based on the fact that they did not return the other funds. Is it required that I put my social security number on the claim form? And the answer is yes. So if you have already filed a claim and have not done so, somebody from my office will be reaching out to you asking for that information. We have reporting requirements to the IRS. So when these cases are set up, they're set up as a qualified settlement fund, which is a separate legal entity under the IRS code. And because of that, we may have reporting requirements to the IRS that will require us to report the amount of money that are returned to investors, in which case, as return of investment, in which cases we will need the tax ID number in order to be able to properly do that. What type of documentation would be sufficient if we believe that the cash flow statement sent with our determination letter needs to be corrected? So if we've sent something out to you saying that we think your claim is X, is $1,000, and you think that it should be higher than that, then we're going to ask you to submit us proof of your investment. And so we may ask for bank statements, copies of checks, wire transfer confirmations, things like that that will help us establish what that amount is. Do I need to do anything besides file a claim form to be considered a claimant? The answer is, you need to file the claim form. But then if we reach out to you and ask for additional information or try to work through an issue, you're going to need to continue to work with us on that. You will still have your claim, but if you don't respond to our requests, it may lead to us requesting that the court deny your claim for lack of information or or missing information. I moved and did not receive any paper documents with my original claim number. I followed the online instructions to file a claim and suspect this has created a new claim number. Is this going to be a problem? No. So to the extent that we end up with two claims for one person, we will ask that you sign something essentially saying that one of your claims is withdrawn, essentially, so we only have one claim for you if we determine that there are two in the system. And so we will work with you to help solve those problems. Obviously, we want to minimize the number of duplicate claims where possible, because that's just extra work that needs to be done. But in some circumstances, it's going to happen, and we will work to get those resolved. Next question. If we gave a check to an investment advisor, how can we know where the funds were invested and thus how to correctly designate them on the claim form? So despite where you put the funds, you need to file a claim for the money that you had put in and let us know that it was invested through an investment advisor and give us their name so that we can ensure that that is properly credited to you. If we do not have that information available to us, we will reach out to you and ask for specific information related to that question. Do you guarantee principal and interest payback? The answer is no. We have no control over the total amount of money that, or I shouldn't say we have no control. We have limited control over the amount of money that we're able to recover for the estate. It is not common to recover 100% of the money that was invested and returned back. So typically when we audit these claims, they would be done on a money in, money out basis, which is every dollar that you put in minus every dollar that you got back, the net of those two will be your claim. So if you put in $1,000 and receive back $100, your claim would be allowed in the amount of $900. And that is typically done in these types of cases because it is very rare to get back 100%. To the extent that we do determine that we're able to recover more than 100%, then we will look to to pay additional money out as it's available. I invested with other members and understood that someone was going to file a claim on behalf of the whole group. However, I don't have confirmation that that was ever done. Is there a way to find out if a claim has officially been made on behalf of the group? If so, do I need to do anything else at this point? So to the extent that you can show us that you are a member of that group, we can verify whether or not a claim has been allowed. If you have questions about that, I would recommend that you file your own claim and let us know that you had invested through this group and you provide us the name of the group. That will allow us to make sure that you at least have a claim in the system. So if that other claim is determined not to exist, or if there's a problem with that claim, you may still be eligible for recovery based on the claim you filed. Is there a difference between investors in the U.S. and investors outside of the U.S.? The answer is no. There is no difference. Everyone is treated the same. The next group of questions has to do with the distribution process. Following the September 11th deadline to file claims, what is the anticipated schedule for processing the claims and starting to distribute funds back to the investors? So we have already begun the process of auditing claims. Our goal is to get through and audit as many of the claims before the end of the claims deadline as possible. Depending on the number of claims that are filed at the last minute, that will extend how long it's going to take us to go through and audit those claims and then be able to make a recommendation to the court. Like I said, our hope is to get as many of them done before the end of the process as possible. But if we end up, with a few hundred claims that are filed in the last day or two, that will then push back the amount of time it's going to take us to finish an audit of those claims. When the claims are audited, they're audited by two people, one person that does an initial audit and then a second person that does a secondary review just to make sure that we've gotten the claims process right. And so that time schedule is going to be based completely on when we get the claims. So I just saw a note pop up that says file them as quickly as possible. That's our goal, right, is to get them in as quickly as possible so that we can get money back out as quickly as possible. So once the claims have been filed and we have gone through and reviewed all the claims, we will then file a motion with the court that says, here's how we think all the claims should be treated. And the court will review that. They may hold a hearing on it. Usually they will. That'll give investors an opportunity to then speak with the court if they disagree with the way that a claim is being treated. And then once the court has adjudicated that, then we will request the permission to do a distribution out to investors. Now, keep in mind that, we're going to be working with investors and claimants throughout the whole entire process. So it's not going to get to the end of the process and all of a sudden you're going to find out that your claim has been denied and you're going to have to go to the court to appeal it. Typically, when that happens, it's because we have been in communication and we just cannot come to an agreement on what that claim is. And so that's, and then it will have to be adjudicated in front of the court at that point. Let's see, the next question. When our funds are recovered, will they be dispersed via wire back to our accounts, or will we have a physical checks mailed out? So typically what has been done in these cases, for well over the last 15 years, I've been doing this type of work, we've always mailed out checks. However, with the amount of fraud that is occurring within the United States postal system and the fact that they've actually requested us not mail checks, we may look at alternative ways to refund money back to investors. And that could be through wire, it could be through an ACH or some other form. So that decision has not yet been made, but we will look at that closely prior to making a decision on how to do it. If it's determined that we're going to do some type of wire or ACH, then we will reach out to investors and request that information at that time. Is it possible to receive a small percentage of our claim before the projected end of 2024? And how could we request this? There's no reason that you should not have received a first disbursement prior to the end of 2024. In fact, we hope that it's much, much closer to the end of 2023, depending on, again, how many claims are filed, when are they filed, and that information, and how long the court takes ultimately to rule on those issues. We don't get any benefit from sitting on the money. There's a certain amount we have to withhold to make sure we can cover any taxes or other liabilities that are due. But we want to get the money back into the hands of investors as quickly as possible. I know sometimes it doesn't always feel that way, but unfortunately, we cannot distribute any money until we know what everybody's owed. The worst, thing that we could possibly ever do is to send money out to people and then have to ask for some of it back because there was something that happened that we weren't aware of. And so we don't ever want that to happen, especially as it relates to somebody like the IRS or another entity like that. We'd rather deal with that all up front and make sure that when people get their money, it's their money and that they don't have any expectation of ever having to give it back. Will any interest that have been accumulated be added as well, or just your initial deposits? So keeping in mind, of course, that the money was never actually invested. The investor money was never actually invested, so there is no interest. But the money that we have collected is sitting in an interest-bearing account, and that interest will be added back to the distribution to claimants. So any interest that's drawn on that account is your money and not mine, and therefore will be distributed back out to investors. Do you expect to make the investors financially whole at the end of this process? I would love to say yes to that, but unfortunately, like I said, in the vast majority of cases, that does not happen. Unfortunately, in these cases, oftentimes the distribution is 25% or less. Now we're in a position where we're already well over that number, and we believe that number will continue to climb. And based on how the litigation occurs and some of the facts that we end up with, it could be that we get closer to that number, that we're going to exceed 50%, or that we may get higher than that. But that that all depends on some very specific things that have to happen related to the litigation, and quite frankly, how much people fight us. When people start fighting to return money that they really shouldn't lawfully have, then it can cause things to slow down and cost more money. So our hope is that people do the right thing and that they return the funds that they need to return without having to sue them to get it, and that we're able to get some pretty successful victories against the attorneys, accountants, and financial institutions that we're seeking to litigate against. You guys will see there will be another motion that's going to be filed in the next few days that's going to lay out some additional litigation that's going to happen against some other parties as well. Does the receiver intend to make more than one distribution to investors, or do investors have to wait for one final distribution? We will do distributions as we can. So as soon as the claims process is approved, we will distribute out the vast majority of the money that we have in our possession, and then we will continue to make distributions as we get lump sums of money. We're not going to, if we get $100,000, we're not probably going to distribute $100,000 because the cost of doing so would be prohibitive. But as we get larger chunks of money, we will do distributions. And in these cases, it's not uncommon to have 2 or 3 distributions throughout the whole entire process, and sometimes even more. Let's see. How will overseas investors recoup any claims that are approved? Typically, any overseas investors, those funds are returned via wire transfer because of the fact that checks are not as easy to negotiate overseas. But we will work on those, that small number of overseas investors we have on a case-by-case basis. When will you know distributions will be made? Well, there'll be a couple things that'll happen. Number one, the distribution process will get approved, and that'll get posted to the website. Notice will get sent out of that. As we do as we prepare the payments the day that they're intending to go out, we will send out another message saying, that these are preparing to go out so that investors can look for them. And then, that way, if they don't see them in the time frame that we expect, then we, would ask that you reach out to us and let us know that you have not received it in that time frame. Will we get notified via email on the resolution process and timeline? Yes, we continue to send out emails as things happen in the case, and we will continue to do that as we move forward. Can we get back at least what we invested given that BOA is the guarantor? I think that is one of probably the biggest misnomers in this case. Part of what the defendants in this case did to sell this investment was saying that these funds were in an FDIC insured account, that is guaranteed by the FDIC through Bank of America. And of course, that is blatantly false. The funds did go into an FDIC insured account. That account, of course, is insured for the benefit of Profit Connect. And so if the bank closed or went into receipt for that, for some reason we lost internet completely. And so so it dropped me off the call. Going back to where we were, talking about the BOA guarantor, I hope that's clear that, that was a definite misstatement of what the guarantee was and who it protected. But we are going to continue to, of course, pursue Bank of America for the claims that we have against them, and we'll continue to do so. Speaking of which, that is the next question related to litigation. Will the B of A lawsuit be used to repay investors? The answer is yes. Any money won there, less the attorney's fees, will be used as repayment to investors. And what is the anticipated time frame of the B of A lawsuit? These lawsuits can take anywhere from months to years, depending on the attorneys that we're working with, how anxious they are to settle the case as opposed to litigate the case. But I would anticipate it's going to take probably a minimum of a year and could take more than that before final resolution is reached. Given the large dollars involved, typically there will be more work that needs to be done in those types of cases. And the last part of this is communication. So what do you do if you have further questions as a result of this call? I recommend that you reach out to my staff at contact@profitconnect-receivership.com. That's profitconnect-receivership.com. Receivership is RECEIVERSHIP. Or you can call us at area code 503-980-3711. The other option you can do, if you've not already filed a claim, is please do get on and file a claim. The website for that is kcconnect.com/Profit Connect. Again, that's kcconnect.com/Profit Connect. The last question here is, will anybody be contacting us in the near future? If you file the claim, it is likely that you may hear from somebody in my office regarding questions that they have. If you file a claim and you have not heard from us, that is generally good news. It means we don't have any questions related to your claim, but if those questions do arise, then we will look to reach out to you to answer those. I do see that my staff has been trying to work with people to answer questions as they've been popping up. And so you will see those, so you'll see those responses in there. It looks like we did get a couple questions. It says you'll be assigned a claims number only after submitting the claim form. That's correct. You'll get a confirmation once you've submitted it on the screen itself, showing that those claims have been received. So the next question was, so why would you send out something saying that what we would receive if it's still years away? We don't anticipate that it's years away at this point. We anticipate that it's months away. And so we will send that out because we want to make sure that we are in full agreement on what those claims are before we start sending money out. Again, if there was uncertainty in the claims process and we sent money out, that could lead to us having to try to recover monies. And we don't ever want to be in that position. So we want to try to do that. When did you start pursuing B of A? I know that there was talk of this from very early on in the investigation. So when did we decide to take action? So we waited to take action until we had finished the forensic accounting, because in order to sue them, we have to know how much money it is that we claim that they are responsible for losing. And so that's why the forensic accounting becomes so important. In addition to working through investor claims, make sure we have a good understanding of what was returned to investors and how much money was lost just as part of the scheme itself. Because as you guys are aware, there's a lot of money that was spent on, in salons and in, buying personal things for homes and expensive dinners and other such things. And in those instances, that money is very difficult to recover. And so that's why we looked at these other third-party sources to help us recover that, including the financial institutions, the attorneys, the accountants, and such. So this has been over 3 years already. The case started in the summer of 2021, as you guys recall. So we are going on 2 full years. We're coming up on 2 full years. But we hope to continue to move through this process as quickly as possible. I'm going to ask my staff to go ahead and put the website for filing a claim in the chat here, as well as the email address, so you guys will have that, so you can get on there and get that information out. But again, if you guys have questions, I strongly encourage you to send us an email or call us on the telephone, and we're happy to work through what those are. But it looks like that is the end of the questions as we have right now. So at this point, I'm going to wrap up the call, but I appreciate you guys taking the time to get involved in the, involved in this, to allow us to talk to you about the claims process a little bit and help give some feedback there. We want this process to be as smooth and seamless as possible. The easier it goes, the less expensive it costs. And we're very, very conscious of the amount of money that we spend doing these things. We know that there are things that have to be done, but we also want to make sure that, we are doing them as efficient as possible, so we're spending as little money as possible. So you guys can provide us a lot of assistance in that manner by making sure that when you file your claims, you're filing them, based on the information that you've been given, and continue to work with us as we reach out to you to try to resolve any issues that might be outstanding. So thank you guys again very much, and I look forward to talking again soon.